Beautiful. Well, hi, everybody. Again, thank you so much for coming to BKC today to join us for our Spring Speaker Series. The BKC Spring Speaker Series is a run of events building upon the success of the Rebooting Social Media Institute's Speaker Series, hoping to face some of the toughest challenges in internet and society today. We've been doing this work for 28 years, but obviously the challenges are changing. And with that, we have to kind of adapt. But we are chilled and chuffed by the challenge of that. And so I'm super excited today to pass it off to our speakers. So thank you for coming.
Welcome, everyone. My name is Jim Tierney. I'm a lecturer in law here at Harvard Law School. I am the director of the State Attorney General Clinic. And a long time ago, I was the Attorney General of my home state, Maine. And today we're here to discuss the role that state attorneys general play in antitrust generally, with specific focus on big tech and the Google case. Antitrust is about choices. Worldwide history has taught us that left completely alone, market forces do not operate in an open and competitive manner. Different societies make those choices in different ways. Here in the United States, at the dawn of the 20th century, the Congress passed the Clayton and Sherman Antitrust Acts, which determined that the primary enforcer of antitrust law in the United States would be the federal government. But
you forgot your mic. People can't hear you. I'm so sorry.
That's all right. It gives Jim a chance to, practice and then be able to speak. It's good for him, and I think better for you, actually, that he practiced a little.
It also feeds the Zoom.
okay, how's that? Is that better? So antitrust is about choices, and the United States determined that its primary enforcer was going to be the federal government. But even then, it divided up the responsibilities between the Federal Trade Commission and the Department of Justice. But even before the federal government acted, states had been active in the field of being concerned about the concentration of power. And never has the Congress preempted or taken states out of the antitrust enforcement business. So throughout this entire period, the states have been operating, doing antitrust enforcement in plain sight. As a matter of fact, 45 years ago, the federal Congress passed another law which authorized attorneys general to go into federal court together or singly to have basically very widespread antitrust enforcement, in some ways even broader than the responsibilities of the federal government. And so today, although you won't learn much about state antitrust enforcement from the academy or from large law firms who oftentimes at their peril ignore state enforcement, we'll talk, we have a real expert here in Jon Sallet, who will be talking specifically about that day-to-day enforcement. It's not the place today to go into the operations of state attorneys general. Let me just say that 43 of them are elected statewide. All of them are partisan, whether elected or appointed. And as you can read, they don't agree on an awful lot of things. But they do agree on antitrust, which is kind of counterintuitive in this world of ours where everyone is talking about divisions. And you'll hear some specific examples as we go along. Every state does not take antitrust with the same degree of priority. That's the point of an attorney general. They get to decide what they want to do. But New York, Wisconsin, California, Florida, Illinois have long been antitrust leaders and operate on an interstate basis. And more recently in Colorado, where the attorney general is actually a former law school dean and an antitrust lawyer himself, you will see Colorado has emerged as an increasing force in the field. Let me just make one small point with big implications when it comes to attorneys general and antitrust. The federal government, with its massive resources in antitrust enforcement, doesn't get to act in an unfettered way. Federal Trade Commission, you need to solicit a certain number of votes from the commission before you can even open a file. On the Department of Justice, they answer not only the Attorney General, but to the various federal agencies, and obviously today, directly to the White House on specific investigations. On the state level, every AG just decides They either say yes or no. I'm going to open the file. I'm going to do it. I'm going to litigate. I'm going to settle. And that extraordinary degree of freedom in the hands of an individual attorney general is unparalleled, really, almost anywhere in our federal system or our state system. So we have a real expert that's going to talk about the coordination between the state and federal government, and that's Jon Sallet. You have his biography in front of you, but let me emphasize just a few points. Jonathan is a graduate of Brown University. He was an editor-in-chief of the University of Virginia Law Review. He clerked for Justice Powell on the Supreme Court and had extensive experience doing litigation and policy work in the federal government in a variety of different agencies. But most recently has taken on the mantle 4 years ago of being a primary counsel in the area of antitrust, having been appointed by the Attorney General of Colorado to assume that role. So, Jon, the podium is all yours.
Thank you, Jim. Let me start by just saying thank you. Thank you to the Berkman Klein Center, whose work I followed, I guess, for all 28 years because of its importance in the understanding and evolution of technology policy. Thank you to Jim Tierney. Jim and I met a long time ago. Looking at us, you wouldn't guess that. I followed Jim's career as he was AG, taught AGs how to be better AGs, taught the rest of us what state AGs can do. And it's been a very important contribution. I also want to just note my Harvard affiliation. I am a research fellow at the Mahsavar Ramani Center at the Kennedy School. And I work for John Haig, who is here, who's center director, co-director with Larry Summers. I've come up over the last few years to talk about tech and competition. Last fall, John and I, for the first time, taught a course, an elective Big Tech and Competition. We're looking forward to teaching it next semester and thereafter because we think it raises some critical questions of law and technology, but also of public policy. What I want to do now, assuming I can make the technology work, is to talk for a few minutes about the Google case. And see if I can get it, go back one. Okay. So let me just tell you how we came into this case. Right, this is the Google search case. There's more than one Google case out there now. We're waiting for a decision in the ad tech case, for example. But we came into it because 5 years ago, actually, I started to work as a special assistant attorney general for the state of Colorado, doing an investigation that was being done by states, a coalition of states, and the Department of Justice. And in late 2020, the Justice Department filed its complaint. In December, we filed our own complaint. We did so for two reasons. One is we felt, the AGs felt, that we had additional enforcement resources to bring to bear. And in the state of competition issues as they exist today, I don't think we can afford not to marshal all the available resources. Secondly, we brought a case that was inclusive of, but broader than the DOJ's case, because we thought there were some implications to Google's search conduct that went further. At the moment, those allegations aren't doing so well. The judge has not accepted them. But we continue on to the next phase because we think we bring a unique perspective. Let me just, this is a coalition of 38 state AGs, states and territories, just about evenly divided between Republicans and Democrats. And in the time since December 20, the more than 4 or 5 years that the case has been pending, those AGs have worked together. We've had a multi-state team of lawyers from the different offices. And I will tell you, there is not once when a strategic or tactical question was debated along partisan lines. This is a coalition of AGs who've come together, as other coalitions of AGs have come together in different cases, to pursue a common goal on a bipartisan basis. I think that's important because I think it brings more firepower to antitrust. I think it's important because it's a pretty good symbol of how law enforcement can proceed. So let me tell you about this order. Now, we're about to talk about a 300-page, almost 300-page order. I'm not going to do it all. Maybe not even every other page. But I want to give you an overview of the theory of liability and what I think are some implications from it. This is the holding, right? You've seen this written up. The court, Judge Mehta in the Federal District Court in DC, held that there are relevant product markets for general search services. That's when you use Google or a search engine. And for a market for search text ads, that's the kind of advertisements that for the longest period of time have been on general search engines. He found that Google has monopoly power in these markets. Its market share numbers for users for what we do is just under 90%. But what I'm going to emphasize is that he found that so-called distribution agreements are exclusive and have anti-competitive effects, right? We talk about big tech, but I want to take a minute and talk about what a court thinks is harm coming from certain big tech actions. And also how the court treated the pro-competitive justifications that Google offered. You know this. This is the way cases like this are litigated. The government shows harm, and if the judge accepts that, he looks at the defendant's explanation of pro-competitive benefits. This is a description of an agreement between Google and Apple. There are multiple agreements in the case, and they are not all of the same kind, but this is a good one to use as an example. So think about how this works. What happens is if you open up a new iPhone and you open up Safari and you do a search in the address bar, you are using Google, okay? It is the default, the so-called default. It's preset. There's debate about how easy it is to change it, but if you just used it as you take it out of the box, you're using Google. And it's significant because the judge found over half of all the search volume in the United States flows through Apple devices. Google pays Apple for the right to have the default. It pays Apple a share of its search ads revenue. So if you use Safari, if you if you run a search for running shoes, and for some reason, every lawyer in this case, whether Google or for the government, always uses running shoes as an example, although I'm not sure why. If you do a search for running shoes and an ad comes up and you click on it, the advertiser pays Google, Google splits that money with Apple. It pays for being the exclusive out-of-the-box default general search engine. That's what GSE is. And in 2022, Google's payment to Apple was an estimated $20 billion on worldwide queries, right? Not just limited to the US. So it's a lot of money flowing through these contracts. Let's just think about the economics of this for a minute, because it tells us important questions about the law. This came from a Microsoft document, but the judge used this to describe how search works. It's a circle. It's a pretty straightforward circle, but it shows the critical questions. It starts by a general search engine needs more users, more of you and me. Because if it gets more users, think of what can happen next. It will get more advertisers, right? This is an advertising platform. Advertisers want to go where there are people to see their ads. It gets more data. The general search engine gets more data about its users. And with more data, it can do searches and experiments, experiments on what people like to see in their results and what makes for an ad that people will respond to better. And that makes the ads more valuable. Of course, all of this through the sale of ads leads to more revenue. The more revenue can be used in different ways. It can invest in development and distribution. But what distribution is something like the Apple contract. With the money, and the court found that there were super competitive profits in the text ad sales, then the money can be spent to get more users. Okay? That's the circle. It's important to understand the circle, and it's important to understand this question. Is it conceivable that somebody new could start a search engine and successfully challenge Google? And what would they have to overcome? They'd have to overcome barriers to entry. The things that make it harder to directly challenge Google. Barriers to entry are what protect monopoly power, because it makes it hard for the monopoly profits to be competed away. In this case, high capital costs, Google's control of key distribution channels, in other words, like the contract with Apple. Brand recognition, everybody knows Google, it's a verb. Scale. The court finds that these barriers exist, and they are significant barriers that protect Google's market dominance in general search. Okay, so what do we mean by scale? What we mean, what the judge says, these are quotes from the opinion, Google's exclusive agreements, right? Just remember, why is it exclusive? Because Apple gives Google the default. Nobody else gets the default. It's exclusive in that sense. Deny rivals access to user queries or scale. Remember back to the circle. If you don't have users, you can't sell ads and you can't get the money and the data that makes you more competitive. Scale is the essential raw material. But just to make it simple, what we call scale, what we're calling scale on this slide is more people, more users, more eyeballs, more data. That's what is critical. Without access to scale, the other rivals have remained at a persistent competitive disadvantage. And this is, I think, important. New entrants cannot hope to achieve a scale that would allow them to compete with Google, right? We want to encourage new businesses. We want to encourage challengers. The judge is saying that doesn't work here because of the exclusive agreements and because of the barriers to entry, most notably scale. In fact, just to give you a background on this, and look, you guys know more about technology than I do, okay? But I'll try. You see if I get it right. Most people get to a general search engine through a browser, right? Some of you have no doubt downloaded apps, but most people go through a browser. Some people go through a search widget that comes preloaded. Android, I believe, is an example. And that is how Google gets to users and how it gets its data. So now we have a competitive disadvantage. But let's go back to Apple just for a second. Apple is a big tech company. Apple is not a new entrant. It's not in this market, but it's not a brand new company. It has a lot of capacity and technology. So the question comes up, is one effect of Google paying billions of dollars to Apple that it discourages Apple from challenging Google? This is very important in antitrust law. Is it discouraging somebody from challenging? The judge found Apple could enter, but it would forego significant revenue from Google if it did. And the prospect of losing tens of billions in guaranteed revenue from Google disincentivized Apple from launching its own search engine when it otherwise has the capacity to do. So if you think about the harm that comes out, you can think about new entrants. I'm going to come back to that. But you can also think about Apple being disincentivized to challenge Google. There's a story I want to tell you. It has to do with a company called Neva, a search engine. Anybody here ever use Neva? I admit I did. Okay, so Neva was a challenger search engine. And its business model was unique in multiple ways, but perhaps most principally because it was a subscription general search engine. And the idea is you wouldn't see ads. So if you didn't want to see ads, you would pay for a subscription. This is not a new thought. I'm assuming somewhere, either in the room or online, there are people who both pay less to Netflix and watch TV with ads, and more to Netflix so they don't have to watch the ads. It's just the same idea. This was Neva's idea, okay? And it started, it was led by a former senior Google executive. It shut down in 2023. Why didn't it succeed? The judge finds Neva could not gain a foothold, in part because it was relegated to less efficient means of distribution. It couldn't, simplified, I think, it couldn't get to be the default on a browser. But the court said the loss of nascent competitors is a clear anti-competitive effect. This is very important in antitrust law. It's companies that don't exist today that could be the most important in bringing competition to bear and the most important in providing additional value, lower prices, higher quality, innovation to you. You know, in the course of a trial, a lot of witnesses come. This was a 42-day trial in the fall of 2023. A lot of witnesses come on stand, and the lawyers always try really hard to pay attention. And they do. There's tables of lawyers in the well of the court. And yet, there are times in a trial where sort of everything stops, where everybody thinks something significant has just happened. In this trial, because it was before a judge and not a jury, the judge asked questions. So one day, this man, Sridhar Ramaswamy, came to testify. He was the CEO of Neva. He was the man who had been at Google for a long time and then went to found Neva, and he made an impression. And we know this because the judge said the court found him to be a particularly compelling witness. And so there's this moment in the court. Of course, the judge is sitting here and Dr. Ramaswamy is sitting there, and we're all out where you are. The judge turns and asks Dr. Ramaswamy a question. Why does Google pay billions of dollars in revenue share, that the split with Apple, when it already has the best search engine? That's the question. And Dr. Ramaswamy said, the payments provide an incredibly strong incentive for the ecosystem to not do anything. They make the ecosystem exceptionally resistant to change. Their net effect is basically to freeze the ecosystem in place. Now think about this for a minute. What's the word we are taught to associate with technology markets? Dynamic, innovative, newfangled, right? We're not taught to associate freeze, frozen, in place with a technology market. And the judge says, no one would ever describe a competitive marketplace in those terms. I thought this was a day when we really learned what the effect of these defaults was. And learned why, in particular, the Google distribution agreements were harming the ability of us to have innovation. Now, that was last August. We're heading into the second phase. The judge found that there was a violation of the Sherman Antitrust Act. We're about to go to a second trial, an evidentiary hearing, on remedies. What should the judge do about it? Google has filed its suggestions. The states, with the Department of Justice, have filed ours. They're public. Some people may have read them. On April 21st, we start that hearing. It's scheduled to go about 3 weeks. And in August, the judge is expected to issue a remedies ruling. This is going to be very important. I'm not going to discuss the remedies issues because it feels to me like maybe I should let the judge be the first one to ask me questions. But I'm sure he will on April 21st when we stand up to do our opening arguments. I think it will be interesting for you to follow. And I think if I just might, in 1 second, because I can see I'm out of time. I think it's a big case. I think it's an important case. But I think it's important beyond the result of this case. I think there are implications for this case about how we understand technology markets, how we understand harm to technology markets, how we understand data and scale, how we understand how consumers make choices. Really important issues about behavioral economics that will guide the outcome of this case, but I think will be very important in other parts of antitrust in the US, but regulation, like the Digital Markets Act in Europe. I think governance of tech markets will learn from this case. So thank you for giving me a minute to give you an overview. Now I'm going to subject myself to questioning even harder than the judge might give me, which is to say from Jim. Oh, I'm supposed to turn this off. I forgot.
Thank you, Jonathan. That's as clear and concise an explanation of this case as I've heard. And it was a very familiar theme. I'm going to start with 2 questions for you. The first is, since we're talking about State Attorney General enforcement of antitrust laws, notice we're really having a structural discussion. The federal government tried this case with you. Is that correct?
Yes.
So you're in the courtroom together.
Same table.
Next to same table.
Same table.
So as far as the public is concerned and the judge is concerned, there was no difference. Tell me, why were the states necessary? Why couldn't the federal government just proceed without a representative from a bunch of elected politicians from all over the country?
Well, there were a couple of reasons. One was we did make some allegations that the DOJ did not. I have to admit, the judge didn't particularly favor those allegations, but we thought they were important. We think they're right. And so we decided to bring the broader case. We work very closely with DOJ, but we sometimes ask different questions. We make different points. We've suggested in the remedies package a remedy that is state-specific. But more than that, even on a day-to-day basis, we work together. We are pooling resources right now on preparations for the hearing, and we'll work together because it's just the point I made before. You know, we don't have a surplus of enforcement resources in the United States, and this is a very big case. The last point I ought to make is we work very cooperatively with the Department of Justice, but remember, the AGs are making their own decisions. And if they want to make a different decision, they take very seriously the obligation to make their own decisions in consultation with, but not necessarily always agreeing with, the Department of Justice.
So my second question is, this case stands on the shoulders and was cited in your representation of the Microsoft case,
Yes.
which came in the late 90s, in which the states co-tried a case with the federal government.
Yes.
And as a matter of fact, a shout out to 2 graduates of Harvard Law School, Steve Houck of New York and Kevin O'Connor from Wisconsin, were the lead counsel who courageously took this. And there was huge pressure at the time that said the states have no role in antitrust generally, but certainly in tech, which by definition goes beyond state borders. I mean, every single thing you do crosses state lines. Why do you need state attorneys general. And indeed, Microsoft launched a furious attack, congressional attack, to eliminate state jurisdiction over big tech, until, of course, Microsoft itself became the victim of behavior from other companies, at which time they changed their tune and said, well, maybe we need state attorneys general after all. But the point is, why should an attorney general in Tennessee or in Colorado, your two lead states, be doing this? What are they doing in a court in Washington, D.C., messing around with national issues?
So I want to talk about what makes an issue national, and I want to then talk about what the states are doing. State attorneys general are concerned about the effect of the people in the state in which they are the AG. A national issue doesn't mean those people aren't affected. It means more people in more states are affected. So if an AG brings a case like the Google search case, he or she knows that the people, the users in their states are among the people being affected. And when states form multi-state coalitions, often bipartisan, to bring an antitrust violation to court, they know they are doing that because the effects are felt in each one of those states. And that's why it's important. National doesn't mean not in a state, it means in more states or in all of the states.
Do attorneys general take this philosophy beyond big tech? What other kinds of antitrust cases are do they get involved with?
And it's important because there are issues, and I'm just going to tag some issues, but that, I'm doing a big tech case now, but there are significant issues. So here are some cases where Colorado, sometimes by itself, sometimes with other states, has worked. I think it's helpful to understand. Healthcare, the question of vertical integration, when a health insurer buys medical practices, for example. Agriculture, Colorado joining the Federal Trade Commission and other states in a case, a pesticides case, against Syngenta and Corteva, which has to do with so-called loyalty actions, right? Getting distributors to distribute your products and not your competitors, in this case, generic pesticides. The RealPage case, I would guess that there's a fair number of people who rent apartments around Harvard University. And this RealPage case goes to the sharing of information between competing landlords. That's just a smattering of issues, but the state AGs working together, different coalitions, are taking on each one of these cases, and by the way, Live Nation Ticketmaster, which is also very important, in which a recent decision, just a week or so ago, upheld the right of the states to not just bring the case, but to collect damages based on the allegation, if it's proven, hasn't been proven yet, that the effect of Live Nation's conduct was to artificially raise ticket prices to consumers. And the states have brought a damages claim.
So states can get damages even where the federal government could not.
They did, the government did not, the federal government did not, but the states are seeking damages and survived a motion to dismiss in order to continue doing that.
So even though we reach a position where the primary antitrust enforcer is the federal government, the states actually in some cases have broader unpreempted authority to challenge anti-competitive behavior. And tell us a little bit about groceries.
Well, you can buy them at supermarkets, but not only. So this was the Kroger-Albertsons case. That was very interesting because there were 3 lawsuits challenging the acquisition of Albertsons by Kroger's. Colorado filed its own case, the state of Washington filed its own case, and the FTC with some states, important states, filed its own case in Oregon. And the merger was abandoned basically on the day that the federal court in Oregon and the state court in Washington ruled that the merger was either illegal or prospectively illegal. That was important because the states understood there that there was very specific local conduct. The backstory on this is there had been a previous Kroger merger acquisition, divested, right? You understand how this works. Two supermarket companies are going to merge. If they own the only two supermarkets in a rural community, then it ends up with one supplier. So a traditional remedy there is you got to sell the other one off before the merger closes to a third party. What had happened in the previous merger was it didn't work. And so Kroger ended up reacquiring many of the stores. General Weiser, my boss, went around to, I think, almost 20 communities in Colorado to hear the stories of what had happened, to hear what the effects on people were. I live in a rural community, right? Supermarkets are not within walking distance, and there aren't that many. So he took this very seriously. And the multiple lawsuits were not all identical. In the Colorado case, there was an assertion still pending that in addition to the merger problem, there was a labor problem. That Kroger and Albertsons at one point had agreed, there was an agreement that limited the hiring of workers between the two companies, which has become a more prominent issue in antitrust. I think bringing those cases at state court, different state courts to federal level, helped bring the full story to bear.
So you see, I think we're about time for questions, I think, from all of you, but you get a sense of the difference between the federal and state government with an emphasis on tech issues. So do we have any questions from the audience or from our chat room?
Hi, I'm Samara. I'm a real and I'm going to work in. Hi, I'm Samara. I'm a 3L. I am going to go work in plaintiff side antitrust next year. I worked actually at DOJ during the time that the Google case was green. I also used to be a software engineer at Google. So yeah, very interesting times. But I was really curious if you can talk about the way that you talked about how DOJ and the state attorneys general collaborate. Can you talk about the sort of connection or lack thereof between state AGs and private plaintiffs' cases on a lot of these similar sort of parallel cases, and the way that you see either synergies or dyssynergies around that?
There was a lot of cooperation in the Google App Store case, in the case alleging anti-competitive conduct associated with the App Store. That case, brought by private plaintiffs and a state case, working very closely together. So it's important. It's important. It's not been in the case I've been in. But in that case, of course, you know, there was a jury verdict for the plaintiffs against Epic versus Google, that private case. And there was, I believe, a class action case, and there was definitely a state AG case. So they can work very much in the same direction.
Yes.
Hi, I'm Allegra. I'm a 1L here and actually interning this summer with the Colorado Attorney General's office in the Consumer Protection
Congratulations.
Section. Thank you. Another question about collaboration. I'm curious, it was great to hear about how states collaborate in the coalitions leading up to trial, but I'm curious how that might change in the remedies phase when you can imagine there might be disparate impacts across state lines, for example, in Kroger Albertsons or other mergers that might have different local effects.
What's interesting is that didn't play out that way in Kroger Albertsons. Of course, some states don't have Krogers or Albertsons in their states, and so this is the kind of merger where certain states will be affected differently than others, but didn't play out differently in what the relief was. In our remedies process, we've all been working in the same direction. And that's true for other antitrust cases that states have joined forces with federal enforcers to do.
And also, when you do a multi-state case, the states internally, using their own mysterious process, will identify a group of states to be the lead counsel. And the rest of the states kind of follow along. And that's simply because it doesn't mean they don't have antitrust divisions. They may be working on something else. They may not be working on the Google case. They may work on the Albertsons case, or an airline case, a JetBlue case, another success of State AGs. So you don't know is the answer. And if you are one of the states that didn't put a lot of resources in, you're not going to continue on your own. If you're one of the lead states, you might very well, even without the federal government.
Well,
Yeah, we have a question from the chat. We don't want to leave them out.
From the chat, yeah. You said that US v. Google will be formative for not just US law, but antitrust generally. Can you give examples of conduct that will carry more regulatory risk because of US v. Google?
I can give examples of analysis because it's all out of the same conduct from the Google case. Here's a couple of pieces. Google argued that as a pro-competitive justification that its search was better, higher quality. And, you know, genuine higher quality is important. It's a pro-competitive outcome. But in this case, to the extent the quality came from getting more users, that it got because of the defaults that were themselves illegal, that's not higher quality. We said in a state filing, that's fruit of the poisonous tree. I think this understanding of the link between anti-competitive practices and what looks like innovation or quality is very important, because I don't think quality that comes from harm to competition, so-called quality, counts. Secondly, behavioral economics. People can change their default. They don't, and it's hard. There was a particular Android example that was discussed in court. The judge put a lot of emphasis on understanding how consumers actually make choices. And that's a matter of behavioral economics. I think as we look at big tech companies in general, understanding the actual effects, not the theoretical effects on consumers, becomes very important. Indeed, here's a third one. Over and over again in his opinion, the judge talked about marketplace realities. Lawyers can look at contract language. We're trained to do this, right? We look at contract language, we say, oh, I know what that means. That's what this effect is going to be. But what the judge looked at was what actually was happening in the marketplace. Not just the theory, not just the language in a contract, but what companies were actually doing. He made this point again and again. And I think that's important because lawyers can give theoretical explanations of how consumers should behave and legal explanations about how contracts allow firms to behave, but they can be, as they were in the Google case, not fully representative of the reality of the situation. And I think looking hard at the marketplace realities is another important implication.
And the third point is that worldwide antitrust enforcers pay attention to each other. Mm-hmm. They follow each other's trials very carefully. They will read the transcripts of daily trials. The EU will be reading on a daily basis the transcripts from the trial in DC and vice versa. And there's a huge level of international antitrust discussion which takes place. So that's the third aspect to your point, that we are in a worldwide marketplace. You can be the Attorney General of Colorado and you're making a huge impact, not just in the United States, but everywhere. Yes?
I have two questions. So first is speaking of the worldwide connection. Okay, thank you. Two quick questions. One is, speaking of the worldwide connection, I'm in touch with a group of folks in Europe who are looking at regulating cloud as a public utility. So there's been a lot of concentration in the cloud space. I'm curious if that's something that you've looked at and whether or not there's a push here in the US, potentially at the state level, to regulate cloud compute as a public utility. And my second question is, there's a group of us that's supported a bill that was recently filed here in Massachusetts on antitrust, and have been in touch with the AG's office here in Massachusetts And they had actually pushed back on the requirement for a bill, saying that actually they had enough case law precedent that they had the tools they needed to do antitrust work effectively and sufficiently. I'm just curious what you think of that comment. Like, do you think, and I'm not a lawyer, so maybe lay way, like, do you think that that is convincing and that there wouldn't be need to do more legislation if there's adequate case law precedent? Thank you.
Well, and the bill was to deal with the cloud issue that you identify? Two separate things. Okay, so I don't know the answer to the second because I don't know what the subject matter of the legislation is, but I will say one thing about this. The antitrust laws were written to be broad. They were written to apply to any industry and any anti-competitive conduct. On the cloud issue, cloud has not been an issue in our case. I've been thinking about it a lot lately, though, because John and I, when we get to our class next fall, are going to talk about AI issues, and we're going to talk about what are the different markets that help create an AI stack, say generative AI stack, and compute, and within compute, cloud is an important issue, right? So next fall, I'll know more about it. I'll be able to answer your question better.
Well, to support the answer, a particular piece of legislation can ironically limit the authority of an antitrust enforcer by taking a particular issue out from the general prosecutorial perspective. And as Jonathan points out, antitrust laws are meant to be broad, and AG offices are dramatically increased in size in the last 5 years and in sophistication. A fact that, as I said earlier, large law firms and the academy seem to lag behind in knowledge of that. But when you're dealing with a state attorney general on antitrust issues, you're dealing with a very sophisticated entity. Now, they may not bring the case that you want to bring, right? But they're just using prosecutorial discretion as opposed to saying, I want a specific, bringing in the Massachusetts legislature into the antitrust discussion is something I was a former legislator. Bringing any legislature into an antitrust discussion is pretty problematic. The laws, I think, are pretty strong, and the enforcement mechanisms are pretty sophisticated. Question from the chat.
Can you speak to the ad tech case against Google? Any reaction to the proposed legislation that would require Google and Facebook to divest advertising units?
I think the answer to that question is Jim can discuss that.
But I'm not going to. It's a wonderful question, and I think we'll be all following that together. But that goes right into the core of prosecutorial discretion and that government has to wrestle with. Great question.
Yeah, very good question.
Yes, I'm Sarah. I'm a graduate of law school and former antitrust.
I'm sorry.
Sorry.
Could you start again?
Can you hear me?
Yes.
I'm Sarah. I'm a graduate of the law school and a former antitrust attorney. My background is transactional. I have a litigation procedure question, which has to do with all these different parties joining an action. When the different states join this kind of action, what level of harm do you have to prove to the residents of your state up front? And does that, or allege at least, and to what extent does that affect your argument at the remedy stage of the case in terms of if damages are awarded, how they get apportioned out between the parties?
So I'm not an expert in this. In our case, where we're seeking only equitable relief, Google search, there's no requirement of showing specific harm to consumers. Indeed, under the Microsoft decision, it doesn't have to be shown in any place, much less in each state. In damages case, like the case that's going forward in Live Nation Ticketmaster, there are different ways that are used to apportion a damages remedy, damages award among states. That's, I believe, a matter for the AGs in each case to decide. Right?
And let me say, because it's a great question which illustrates the difference between the plaintiff's bar and the federal government and state AG enforcement. If you're on the federal side, and certainly if you're on the plaintiff's side, when you're talking about damages, you're talking about money. because that's how you get paid, right? You worry about money. If you're the state attorney general, it may look like a very small case in Washington. But if it's a case of leaving an entire county a food desert where there's no grocery store around, if it's a question of losing a series of counties from any serious health care in a particular specialty because it didn't make enough money to generate, this is where state attorneys general have a huge value added because they're on the ground. And when the federal government is operating appropriately, they're listening to the states and they go, oh, okay, food desert, I get it. That's really important to human beings and how they live their lives. And that can get lost when you get into the antitrust theories and the charts, the graphs and the economics. And that's why I'm a fan of state attorneys general bringing vigorous antitrust authority. But that's one of the reasons you can't always count it with dollars and cents.
It's true. Our case is not about dollars and cents, but it is about competition and innovation.
I think we're down to just like a minute left.
Yeah.
Yes?
And then can I take a
Yeah,
minute
yeah,
at
take the
end?
minute, John.
You want to do one question and then I'll just close?
Shoot.
You mentioned the EU, and I'm concerned about the recent decisions that open up the App Store to other people's apps that have not gone through the very careful screening, knowing how cybercrime is a major thing. And if one person adds such an app to his phone, it might actually infiltrate the whole network. Have you thought about that? I mean, and what do you think about the EU's approach?
Well, I should have said at the outset, right? It's obvious that I'm giving my own opinions and I'm not speaking for the Colorado AG's office. I think the DMA is a very interesting statute in the way that it deals with gatekeeper power. As I understand the DMA, one very specific provision is that a company can raise as kind of a defense, it's not technically a defense, I don't think, threats to security. I think threats to security need to be taken seriously. But the history of antitrust is that not every claim of a threat to security was in fact a threat to security, and here's the case. 1956, you had a telephone. It was a black thing. It looked like this. It was heavy, it was obsolete, but here's the one thing. When it rang, you never had to look in your pockets to figure out where the phone was. It had that advantage. Guy invents a piece of plastic to go over the end of it, so you could talk into it in a noisy environment and the background noise would be shielded. It's just a piece of plastic. It was called Hushaphone. When I was a young lawyer, I went to a law firm where the senior partner had argued the Hushaphone case in the DC Circuit against the defense by AT&T that putting this piece of plastic on an old-fashioned phone would create a security threat to the network. It wasn't true. I think we have to protect security. I think we have to take these issues very, very seriously. But I think they require careful examination before one accepts every security claim that is made.
Okay, John, how about a few parting words for all of us?
I just want to say this. I'm very fortunate to have the job I do with the Colorado AG's office. This is a coalition that's run by the Attorney General of Colorado, Phil Weiser, the Attorney General of Tennessee, Jonathan Scometti, with an executive committee of states, with lawyers from multiple states. I got to tell you, one of the great things about doing this case was being at trial and seeing young lawyers get their first chance at a major antitrust trial. Lawyers from different states around the country stand up and do an examination of a CEO of a major tech company or a cross-examination. This was unparalleled opportunity for them. It was wonderful to watch, but it also has this lesson. The more cases that state AGs bring, the more state AG lawyers that get these kinds of experiences, the more effective will be these offices, the more effective will be the litigation that they bring in the future. So we're litigating in the present and we're building for the future.
Thank you, John.
Thank you.